On Friday, the Supreme Court will decide for the first time whether to accept appeals from defendants accused of crimes connected to the January 6, 2021 attack on the U.S. Capitol. These cases could have a significant effect on the criminal prosecution of former President Donald Trump. The justices will review 3 separate appeals filed by defendants Joseph Fisher, Edward Lang, and Garrett Miller during their routine private conference to decide which new cases to take up. The 3 men are attempting to have a case against them dismissed on the grounds that they interfered with an official proceeding, specifically the congressional certification of President Joe Biden's election victory, which was interfered with by a group of Trump supporters. In his federal election interference case, Trump faces charges related to the same violation as well as other offenses. Therefore, his case may be impacted by the court's decision to accept or reject the appeals. A lower court decision that permitted the government to press charges against the defendants would stand if the court rejects the appeals. However, if the justices decide to take on the cases, there would be a lengthy wait as they consider oral arguments and render a decision at some point in the court's current 9-month term, which ends in June. The 9-justice court must have 4 votes or more in order to hear a case. The conservative Justice Clarence Thomas did not take part in the Supreme Court's previous consideration of a case pertaining to January 6. John Eastman, a former Thomas law clerk who gave Trump advice on January 6, was involved in that case. In addition, Thomas' spouse, Virginia Ginny Thomas, a conservative political activist, openly backed Trump's attempts to rig the 2020 election. The Supreme Court's participation may present one avenue for Trump's attorneys to postpone his trial for alleged election meddling, which is set to begin in March. Trump could credibly ask to delay his trial until the case is resolved, according to Randall Eliason, a former federal prosecutor and George Washington University Law School professor, should the court decide to hear the cases. The trial might still take place before the election, he continued, with the court's decision probably coming before the end of June in that case. As the current frontrunner in the Republican presidential contest polls, Trump stands to gain from any postponement of his criminal trial in Washington. Trump would be able to get the charges dropped if he were to win the election in November. Should the trial proceed as planned in March and Trump be found guilty, his sentence might be announced prior to the election. The election meddling case is one of 4 criminal prosecutions Trump is battling. It may also have an impact on other January 6 defendants facing comparable allegations. Jack Smith, the special attorney, brought 2, while New York and Georgia brought the other 2. Trump stated on his Truth Social platform 3 days after he was charged in the case of January 6 that the accusations against him amounted to election meddling and that the Supreme Court must intervene. The sole clause under consideration in the Supreme Court appeals is 18 U.S.C. 1512(2) of the U.S. Code, which makes it illegal to attempt to corruptly hinder, influence, or impede any official activity. A conviction carries a maximum 20-year jail sentence. According to the Justice Department, proceedings before Congress are included under the definition of official proceeding. The Sarbanes-Oxley Act, a piece of legislation passed in the wake of the Enron accounting crisis, included the provision when it was introduced in 2002. Defendants argue that it was never meant to apply to an incident like the one that happened on January 6. Trump's attorneys argued that the indictment applies a statute directed at the destruction of records in accounting fraud to disputing the outcome of a presidential election, in an attempt to have the prosecution dismissed in the federal election case. This goes beyond any logical connection to the text of the statute. Because Trump did not take part in the Capitol attack, the application of the provision in his case may also give rise to concerns unrelated to those in the Supreme Court appeals. Defense attorneys have argued in lower courts that the act has been construed too liberally and have questioned whether the term corruptly can be used in their cases, because they believe it only relates to tampering with evidence and not, for instance, assaulting a police officer. The first of multiple accusations that each of the 3 January 6 suspects faces was first dismissed by U.S. District Judge Carl Nichols, who is in charge of their criminal proceedings. However, the U.S. Court of Appeals for the District of Columbia Circuit found 2-1 in favor of the government in a decision from April. Each of the 3 judges had a different line of reason.